really, we could do a sort of multi-day seminar on the inherent jurisdiction, and that maybe we picked a topic that was rather too big.
That's next time.
So those who want to sign up for the multi-day seminar, we'll come back to details of that. But in the meantime, we've tried to narrow down what we're talking about here. The inherent jurisdiction, as Lady Justice Black helpfully told us in Read J some years ago, is a phrase which is used to mean two quite different but connected things. So sometimes it's used to mean the substantive powers that the court can make. So Emily was talking a minute ago about applications for tip-staff orders and revealing a child's location. These are substantive powers under the inherent jurisdiction, and we're not talking about that. We're talking about the other part of the inherent jurisdiction, which is the use of it as your basis for saying the court has any jurisdiction to make any orders at all. And that's effectively an alternative to saying you've got a habitual residence jurisdiction or you've got a presence jurisdiction. And it's sometimes referred to as the nationality jurisdiction. It's the idea that you've got a claim over this child in the English courts because of nationality. And this is a very old jurisdiction, and the case law on this goes way back into the 1800s. For those who come to the multi-day seminar, we'll go into that. But you can see this is a quotation on the left from Lord Denning from the 1960s, basically asserting a then well-established view that if you have a child who is a British national, they owe allegiance to the British Crown, and therefore, of course, the British courts, exercising the power of the Crown, can take protective measures as the quid pro quo for that allegiance. Of course. More recently, the judges have commented about the sort of infinite variety of circumstances that we see these cases arising in. And there's this temptation, I think, for all of us who practice, particularly with international children cases, to think we're not really quite sure what basis the jurisdiction of the English court's being invoked on, particularly children who are no longer physically here. But it'll all be fine because we use the inherent jurisdiction. And that is a very, I don't know, comforting thought, that it'll all be fine because we use the inherent jurisdiction. But it brings us to the sort of substantive content of what we were going to talk about today, which is why you should not be so comforted by that thought as you might at first have hoped. So I'll hand over to Meg to take us through a couple of the big cases, and then we'll have a short discussion afterwards.
Oh, should we go back to that?
Did I skip something? Oh, I skipped.
You can go back if you want.
Well, I can do this now. Or we can do it afterwards. I'll do it now. You see what I mean about the lack of banter. Let me have a copy of the slides.
I've already got mine. So sorry.
So there's the first reason not to be as comforted as you might have thought is that we have to be conscious that back in the day, when Lord Denning was giving his judgment in the 1960s, the jurisdiction of the court was fairly unencumbered by statutory or international law limitations. That is no longer true, and there are two principal things to be aware of as to obstacles to the invocation of the inherent jurisdiction. The first and most likely to apply it, maybe, I might retract that, but very likely to apply in a lot of international cases, is that the 1996 Hague Convention applies to your case. So there's two stages to deciding if the convention applies. The first is, substantively, does the issue fall within the scope of the convention? So not every aspect of child law is within the scope of the convention. So if your issue is determining parentage, for example, it's not within the scope of the convention. But most of the kind of private law orders that we might be concerned with are. So first step, is it within the scope of the convention? Second step, is the child in another state which is also a signatory to the convention? Those of us who made good use of the Brussels 2A regulation will recall that the courts determined that it applied irrespective of whether the other country was a an EU member state or not. Edward had a great deal of difficulty with these decisions, and tried to persuade many a judge that the Court of Appeal was wrong about that. That obviously for us is now a moot question, but the 96 Convention doesn't have that universality about it. No one has suggested that if you've got a country that isn't a 96 Hague Convention state, you should nonetheless apply the Convention's provisions. So if you're not applying the 96 Convention, you are likely to be then in the territory of the impenetrable and incomprehensible 1986 Family Law Act's jurisdictional provisions. I've read sections 1 through 3 more times than I care to admit, and I don't think I really understand them. But basically, if you have jurisdiction governed by the Act, which again is primarily to do with the substance of what you are ordering, any Section 8 order under the Children Act, anything under the inherent jurisdiction's substantive powers to do with the care, contact or education arrangements of a child, it's governed by the 86 Act. And that means you either have to have habitual residence or you have to have physical presence. Neither of which you're likely to have if you're thinking about invoking the inherent jurisdiction based on nationality. So the starting point from the statutes and the convention is to say you've got to be really careful that you're not accidentally breaching these provisions.